Hello friends, in the series on the income tax cases, today we will discuss a totally new case which does not come very regularly. The issue before the Patna High Court in the present case was that if the assessee is involved in some scam and that scam is related to siphoning of the government funds which has been released by the state government in conjunction with the central government for giving the relief to the poor people during a flood situation, and the assessee's role was that the assessee has to purchase various material and distribute it to the flood affected areas, and the assessee siphoned off this money and does not distribute that material. So whether the addition for that amount which has been alleged on the assessee that the assessee has siphoned off, whether this type of additions are also justified. This issue has been taken up by Honorable Patna High Court in the case of Santosh Kumar Jha versus Deputy Commissioner of Income Tax, and this case is reported in 482 ITR at page number 211. The date of the judgment is 16th February 2024. The present case relates to the assessment year 2005-2006. In the present case, the assessee was a proprietor of two concerns, and the main business of the assessee was supplying materials to the Bihar government in its various departments. According to the facts of the case, there was a huge flood in 2004 in 6 districts of Bihar state, and those districts were very badly affected by the flood. The state government, with the help of the central government, started various schemes for helping the flood affected areas, and an amount of rupees 17.8 crore rupees was given to the assessee for purchasing the various material and giving to the people for the flood affected areas. But after that, when the amount was given, it came to the knowledge of the government that there was a scam on the part of the assessee, and the assessee has transferred this amount to various relatives of the assessee, and from there that amount has been withdrawn. And for that, even the first information report was done, FIR was done against the assessee, and even the forensic report was taken, and the statement of the branch manager of the branch was also recorded under oath. And from all these things, it was very clear that the assessee has not supplied any material and the assessee has siphoned off the money. These facts were also before the assessing officer, and the assessing officer, while completing the assessment proceedings, made the addition of the amount of the siphoned amount into the income of the assessee. But the plea of the assessee was that the assessee has supplied the material in excess of the amount which has been received by the assessee, and the assessee has filed a suit also for the recovery of the money from the state government. But the assessee grossly failed to substantiate with the evidences that the assessee has purchased the material and supplied to the various departments. Whatever the addition was made by the learned assessing officer, that was upheld by the learned CIT appeal and the honorable tribunal. And when this matter came before the Patna High Court, the court said that there is no denying the fact that there was a huge scam, and the assessee is very well engaged in that scam by transferring the money which has been received by the assessee from the state government in conjunction with the central government, and that amount has been transferred by the assessee to the various relatives of the assessee and various concerns which was related with the assessee, and from there the amount has been withdrawn. So there was no doubt that there was a scam, and the assessee has grossly failed to substantiate that the assessee has made supplies to the state government from the amount which has been received by the assessee, and that all the amount has been received from the state government has been misapplied for the personal and for the alleged purposes by the assessee. So in such a scenario, whatever the additions have been made by the learned assessing officer and have been upheld by the tribunal was justified. So the court also upheld the assessment order. So friends, from this case it is very clear that if some person siphoned off some government money, some money which is related to some schemes, then it can also be added into the income of the assessee if the assessee is not able to prove otherwise. At the end of this video, once again I am repeating the name of the case. The name of the case is Santosh Kumar Jha versus Deputy Commissioner of Income Tax, and this case is reported in 482 ITR at page number 211, and the date of the judgment is 16th February 2024. Thank you, friends.